Hey everyone, welcome back. Today we revisit Albert Hicks, the self-proclaimed sovereign citizen. Last time, he squared off against a lenient judge and dominated the commentary, if not the case. But today, Hicks faces Judge Perkins, a master of courtroom control who doesn't tolerate pseudo-legal nonsense. We'll break down two explosive appearances that show exactly why Perkins runs a tight ship. Grab a drink, hit like, and let's dive in.
Versus Albert Hicks Jr., case numbers SP 1442547, counts 1, 2, and 3, SP 1442765 It looks like the rest of this stuff. Then I have SP 1500872 and it looks like the rest of this stuff he's already entered a plea into all this stuff.
No, sir. No plea.
Well, that's not what it says here, sir.
I represent myself. I couldn't enter the plea. I never plea. You can check my record. I never plea.
Oh, maybe I found you guilty then. Yeah.
No, I haven't been. Matter of fact, I came inside there personally a week or so ago. And the young lady, the security officer, came out and said that I'm supposed to report today.
No, this is on some old stuff. All right.
I never entered the plea.
So do you not want the representation of counsel?
No, thank you.
Okay. There you go, Mr. Take. That's your first break of the day, Mr. Soroki. You know what I mean?
Judge, I know how to deal with everybody. So I said I know how to deal with everybody. Any type of client.
Yeah, I know, but he doesn't want it.
Right,
So
I understand.
We can't force it on him.
No, I understand.
So you can
take it as a plus.
The moment the self-proclaimed legal genius fired his attorney and chose to represent himself, he turned a simple hearing into a one-man disaster. What he calls taking control is pure chaos, crayons, YouTube law, and imaginary rules everywhere. Every word he speaks digs him deeper, and the judge is ready with a legal shovel to keep him trapped in the hole he created.
So, Mr. Lee, today is the date and time set for a show cause. As for purposes of arraignment, sir. We'll do it like this. I'll enter a not guilty.
Are you talking to Mr. Hicks or Mr. Lee?
Pardon me?
Yes, you should be able to follow the first one.
Are you talking to Mr. Hicks or Mr. Lee?
Mr. Hicks, I'm sorry.
Yep, you should be down with area code 929.
Mr. Hicks, for purposes of arraignment, I'm going to enter a not guilty plea on your behalf and give you a $0 bond, all right?
I object, Your Honor. That would be practicing in front of the bench.
It's the same process.
Say that again.
I object. That would be practicing in front of the bench. Practicing law from the bench. You will have to recluse yourself if you hold on to that.
Yeah, it's one of those days. Words fail, confidence clashes with confusion, and grammar takes the first hit. Every sentence becomes a puzzle for the judge, forcing him to decode exactly what this sovereign citizen thinks he's arguing, turning the hearing into a non-stop exercise in frustration and chaos.
All right. Well, I deny your motion. So go ahead. How do you want to proceed?
I would like for everything to be dismissed, if it pleases the court.
Deny. What basis?
You haven't even let me tell my grounds.
All right, basis. Give it to me.
He's gonna bring you.
For one, a ticket is a bill of attainder. Article 1, Section 9, Clause 3. of the Constitution of the United States, no bill of attainder or ex post facto law shall be passed. You can have a written assistance.
All right, let me stop.
Equity that transmits into law penalties.
Let me stop you right there. Let me stop you right there. We have, first of all, we have a problem with the transmission. You're breaking up really, really, really bad, and we can't get that on the, turn your video off. Maybe turn your video off. That will help. Let's see. All right, try it now. Try it now. Let's see. Go ahead.
Did you hear what I said?
Yeah, I'm listening.
Okay. Article 1, Section 9, Clause 3 of the Constitution of the United States. No bill of attainder or ex post facto law shall be passed. You cannot have a writ of assistance that has civil equity that transmits into law. Number 2, there is no sworn statement from an injured party. Number 3, the officer did not even sign the ticket. That's under law of penalty of perjury. I'm asking that all of these be dismissed.
Ask all you want, but victory won't come when your argument collapses under its own weight. First, he claims the officer perjured by signing a false ticket, then seconds later insists the officer didn't sign it at all, contradicting himself mid-breath. It's like arguing both sides of a coin and losing the flip. Judge Perkins doesn't hesitate. Motion denied. Clear, firm, uncompromising. He's not here for word games.
All right, I'm going to deny that motion. All right, how else do you want to proceed?
That's your declaratory judgment?
I'm going to deny the motion. I denied the motion.
Okay, let's go to court.
Trial?
It don't matter, because I don't understand how y'all run y'all system. Y'all practice against the law. I'm a common law.
Well, read the court rules, and you'll learn a little something.
The court rules go against the law. Y'all practice against the law, against the Constitution. I'm all common law.
All right. Well, we're beyond that.
Okay.
All right.
So you say. So are you going to prosecute this, or somebody else going to prosecute it?
Stop. Let's not keep going. All right. You want a trial date, or not?
It's up to y'all. Remember, y'all make all the rules.
Trial date. You want to? Let's give him a jury trial date.
Jury trial.
Yeah.
How long do I have to turn in my briefs?
I'll give you some dates in a second.
Okay. Scamming. With a smile on your face. If it pleases the court, what jurisdiction are you charging me on?
I asked the question, sir.
I just said if it pleases the court.
I know, and I'm telling you, I asked the questions. I appreciate your respect for the court, but I asked the questions. I told you to read the court rules.
You can do it March the 5th. Let me check and see.
The court rules is a March jurisdiction are you trying to charge me on?
That wraps the first hearing. The next court date was set for mid-June, but Mr. Mac Confusion clearly wasn't listening. Instead, he strolls in the following week like it's showtime, armed with an outdated notice printed before the last hearing. The judge had already rescheduled for June, yet he walks into the wrong fight on the wrong day, convinced he's winning. The confusion on his face says it all, like crashing a sequel before the script was even written.
Is March the 5th a good date for you, sir?
No.
Okay.
June the 11th is going to be the jury trial date.
June the 11th?
June the 11th. So let's put your final pretrial date will be Let's see, put that a day before. That way, that'll be the date we'll our motions on June the 10th. May the 24th will be your motion, and now these
May 24th.
May the 24th, and the city will have 7 days to respond. So the response motion will be due by May the 31st.
I appreciate you, Your Honor.
All right, have a very good day, sir. Best of luck to you.
I just did. Thank you.
He's the judge. No explanations, no justifications needed. That's the power of the bench. As Judge Brian Oakley said, the robe doesn't give authority. It reminds everyone that you already have it. Judge Perkins knows when to listen, when to cut through nonsense, and when to make it crystal clear. Courtroom debates aren't democratic. His courtroom, his rules, his final word, unchallengeable and absolute.
Good morning. You have a final pretrial set for June the 10th, and you have a trial date. You have a final pretrial set for June the 10th, and a jury trial date set for the same day. Okay, that's not correct.
Yeah, you did.
Hold on one second. Let's get the date straight.
I'm not here for that.
What are you here for, sir?
The slip says for Jonathan Reeves.
Jonathan Reeves.
Yes.
I don't know anything about it. Jonathan Reeves. Let's see. Maybe. I don't know anything about a Jonathan Reeves.
Well, I motion for this case.
Are you Mr. Hicks? Are you Albert Hicks?
Yes, I am.
Okay, so we're going to get you your dates, and that Jonathan Reeves.
I already have my dates. I talked to you last week, remember?
I think it's correct.
I have June the 10th and June the 11th.
Very well. Okay, we'll see you back on those dates, sir.
But this matter right here with this Jonathan Reeves.
Well, what does Jonathan Reeves have to do with you?
That's what I'm here for court for today. I'm making a personal special appearance for this.
Okay, I don't know. Who is Jonathan Reeves? Do you know who that is? What does it say on that? Because it sounds like it may be Jonathan Reeves may have stayed at that address at some point and left. I don't know what that's all about.
That's why I'm asking that this case be dismissed. The case is SP 15008721.
SP 15008721. Okay, that's not Jonathan. Okay, Jonathan Reeves is the officer that apparently wrote the ticket.
And where?
And that's scheduled for the final pretrial on, I see where he's here today. It says scheduled for pretrial today. But that's all going to be handled on the 11th of, Jonathan Reeves is supposed to be here on the 11th of June on the day.
I was not notified. 11th of June.
Yeah.
How was he going to be here on the 11th of June? And I have Spidell on the 11th of June.
You have a couple of different officers, obviously.
Jonathan Reeves and Spidell has nothing to do with each other.
Well, we're just consolidating. We're having all of
Why
them.
would you do that against my will? Why would you just do that?
I'm doing it because of the judicial economy, sir. So
I'm challenging that one.
Okay, then write a motion, and we'll rule on it. But it's all in the same. We're all going to do it on the same day.
You didn't ask me that.
He's the judge. His courtroom, his rules, non-negotiable. Speak out of turn, and he'll remind you who's in charge. Judges like Perkins don't debate defiance, they crush it. Push your luck, and your title upgrades from common law freeman to county inmate before you can spell jurisdiction. Reality check. The courtroom isn't a stage, and the judge isn't your audience.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay?
I don't have to ask.
You didn't ask me that. You just arbitrarily did it. That's not right. That goes against my rights.
All right. Well, you can put it in a motion, sir.
Well, the whole thing is, I don't know what y'all doing down there, but you are totally infringing on my rights.
Okay, well, file a motion, sir. That's how you speak to the
Why
court.
would I have to file a motion when you infringed on my rights? And I'm saying it right here, right now.
That's what the court rules are. You got to follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public information.
You're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right?
My honor. Please. I'm bringing up valid litigation for this. I don't know what y'all doing. Y'all can't do anything without my permission. I'm not a ward of the state.
Mr. Hicks.
I'm an unfranchised common law free man.
Mr. Hicks, all I ask you to do is you can file a motion. You can put all of that stuff in the motion.
Yeah, so you can come back and say motion denied, right? Like you did last time.
Well, that's my discretion. If I don't feel that if it doesn't meet the criteria of the law, then that's what my
jurisdiction are we?
I'm not going to answer this question, sir.
Oh, you're not going to answer the questions? Then I would like to know your status.
You don't ask the questions. I ask the questions. That's how.
You're going to play like that. What is your status? I am a common law free man. What is your status?
You're allegedly a criminal, but the real reason you're here wasting everyone's time is simple. You weren't paying attention. Ignored instructions, checked out last hearing, and now you're back wondering what went wrong. Courtroom déjà vu, except the only one surprised is you. The judge isn't angry. He's done babysitting adults who treat hearings like improv.
All right.
Over. Okay.
So let me finish, and I'll let you speak. If you're not going to do it that way, you're either going to get out the room, or you're going to I'm going to lock you up. All right. So today is the date and time set for a pretrial, and this pretrial, the officer is not required to be here for a pretrial. The pretrial date is set in order for you to get an offer to either settle up the case, or in this case, we're setting a trial date. You have dates already set. The date motion due is going to be on May the 24th, 2024. The response to that motion, if the city chooses to respond, is going to be on May 31st, 2024. Your next court date that you need to be present is going to be on June 10th, 2024 at 8:35, with the jury trial set the next day on June 11th, 2024 at 9:35. Okay? Now, I'll let you speak, and we're going to end it.
Is all of this on record?
This is all on record.
Is all of this on record?
Yes.
Okay, please send the information to my home, please.
What a disaster. All that chaos over a simple mailing request on the record. Proof that common sense left the building long ago. This guy turns courtroom appearances into performance art, and not the good kind. That's it for today. Won't see this self-proclaimed legal scholar for months. But I've got at least 3 more Sovereign Glue sniffers coming next week to keep you entertained. Hit like if you enjoyed, dislike if you didn't. It still feeds the algorithm. Drop a comment, subscribe with notifications, and remember, every self-taught attorney walking into court is a free lesson in what not to do. Buckle up, stay tuned. Same madness, new defendant, and the law still undefeated.